Project and Common Core of European Private Law, and most recently the author with Laura Nader of the provocatively titled book, Plunder, When the Rule of Law is Illegal, and General Gadfly. Ugo Mattei.
Thank you very much for organizing this, and this is the first time in which I share these thoughts with an international audience. This is a story that is unfolding here in this country, in Italy, and that I claim has some global significance as a proxy of transformations that are happening in a variety of places, of course, with the usual contextual variations. The claim, this is a paper that is much less theoretical than much of the stuff that we've been discussed in this couple of days. It's really pretty much a participated observation of a constitutional clash that is happening in this country in this last 2.5 years or so. That has showed a lot of changes in the constitutional ordering as a consequence of the 2008 crisis. So it is a paper in a way that much discusses the present and therefore does not have neither the historical detachment that sometimes is needed in order to make scholarly or scientific analysis, nor it has the political detachment that usually is also considered a good thing for scholarship, because I've been involved personally and very physically in this whole adventure. So I do these two disclaimers, but I thought that it would be of some interest to have some materials here to discuss what actually is occurring here. The story starts with a deep critique of the privatization model of the economy that in Italy started early in the 90s. Italy was the country that privatized most resources of the world in the period between 1992 and 1998. So there was a massive privatization offered. We had a very large public sector, and this public sector was basically dismantled by the need to enter in Europe. It was the karma at the time. After this early phase of privatization that was also was justified by a very large public deficit and public debt, the decrease of the actual public debt was very minimal. We privatized assets for the value of 140 billion euros, so we're talking about serious money. And the ratio of indebtedness went down at its peak less than 10 points. Okay? So those results that were not exciting, if you sell basically whatever you have and you're still in big trouble, you can just think it over, generated some scholarly thoughts and some analysis of what was going on on privatizations. And those scholarly analyses basically showed a very significant imbalance of legal protection of privatization processes as opposed to taking for just compensation purposes. In other words, the observation was that while it is quite difficult to transfer from the private sector to the public sector, because of all the liberal, classical constitutional guarantees, due process of law, just compensation, public interest, and so on and so forth. Privatization, on the other hand, is very simple and is considered one of the normal prerogatives of any government in power. That is to say that privatization can happen, and this is not something that is happening only in Italy, but practically everywhere, outside of due process guarantees, with no need of public interest procedure, nor there is any public compensation for the assets that have been privatized. Because the assumption is that the state is actually the owner of whatever is public. And the public-private distinction, that is basically the grammar of legal and political discourse in the current Western democracies, basically grants into the state the full power to take care of its people because the state is considered legitimate, per se. However, analysis of the way in which privatization occurred shows that such privatization have been deeply affected by a massive structural conflict of interest. Assets were usually sold at cheap value, and the result of privatizations was usually the lowering of the quality of the service, the increasing of the salaries of the management, the increasing of the budget for advertising, which in turn is the way in which the private sector controls the public sectors by corrupting the politicians. So that problem was faced in a long period of time and generated an analysis that was carried on in the Accademia Nazionale dei Lincei, and that later produced the foundation of a commission that was chaired by Professor Rodotà, who is a well-known property law scholar, that was in charge to try to take care of this imbalance between the private and the public. And the commission worked for about a year. It was a large commission at the Ministry of Justice during the former government, the Prodi government. And we produced in 2008, I served as a vice president of this commission, we produced in 2008 a draft proposal of a statute that was basically reordering private and public property within the civil code and generated the notion of the commons as a notion, a legal notion that cannot be confused neither with private property nor with public property, that has its own identity, and the identity is based on direct access of the utilities produced by such commons in the interest of full satisfaction of fundamental rights and in the interest of future populations. In other words, the commons were a category that could not be privatized in the way in which every other public good or utility could, because they were not entrusted to the state, but they were actually to be defended by the people directly in the interest of the future generation. So there was this strong attempt to create a notion that would basically grant some protection to public property rights, also against the state. On the theory that the state is weak, globalization made, and this is, we have the masters here, we have Saskia and others, but the globalization basically produced a fundamental change in the power ratio between the so-called private or corporate sector and the public sector, so that in privatization really, in globalization really, no state can be considered fully sovereign. But states are actually controlled to a large extent by the aggregate of private interests that are the strong transnational corporations. And the processes of control are very clear, capture theory of legislation, the difficulty of getting elected to office outside of being part of an elite which is wealthy and rich, and therefore this needs a lot of money to get to office. So this kind of thing generated this bill, and this bill kind of used water as the symbol of a common, a resource that could not be fully managed neither privately nor publicly, that was actually directly concerned with the needs of the person. You cannot live without water. That doesn't really work within the traditional positivistic idea of a subject owning an object, because we are water. We're not only owning water, but water is really deeply part of us. And water actually has been the object of a lot of political tensions through the world, particularly 2000 in Bolivia was the great example of a struggle, of a people struggle for the defense of access to water as a fundamental precondition of existence. When the Rodotà bill was presented in Senate, it was November 27 of 2009. We had already the new government in office. In the very same day in which there was a presentation in Senate, with a lot of public ceremony, on the other side of the palace, in the House of Representatives, passed a bill that made it compulsory to privatize all public services by the end of 2011. So there was this incredibly schizophrenic thing that on the one hand, on the one side of Parliament, scholars and intellectuals were producing ideas of legislation that tried to take care of the big picture. On the other side, they were doing real business, and the real business was to privatize all the utility systems. And of course the theory there was, well, we're not really touching the object. We are not really privatizing the water. What we're doing is just privatizing the service, right? So there was this very smart move of saying, one thing is the object, one thing is the substance, water remains public, however, all the management gets privatized obligatorily by the end of the year. We know very well that if we look at the commons, at any common pool resource, and we get a little understanding of ordinary corporate law literature, that managing a commodity is the closer thing to owning it in the global scenario. It's very difficult to say that the owners are the shareholders, the owners are the managers, more and more. This legal theory struggles with these ideas, but if we look at it from the political and economic point of view, it is very difficult to claim elsewhere. So, as a reaction to that, a referendum was organized. A referendum was organized to try to abolish the statute that privatized the stuff. And this referendum was extremely difficult, because in Italy it is difficult to run a referendum. Referendum is introduced in our constitutional setting as a very exceptional tool, can be used only when really Parliament seems to be betraying its role, and the people would kind of take back sovereignty in order to exercise it, to stop, to veto some decision. In order to produce a referendum, you need to have something to abolish. We do not have the propositional referendum. Plus, you need to have a turnout of at least 50% plus one of the population, which is extremely high. When it was already conceived as high at the time in which people used to vote, now with normal turnouts at elections in the 60%, you can see that 50% is really very, very high. Therefore, the strategy of power against referendum has long been that of making the referendum fail but not reaching the result. And it's pretty simple in a system in which government controls, government meaning Berlusconi at the time, controlled both the public and the private media industry. And the rest of the media industry that was not controlled by the tycoon was anyway controlled by a political party who had a lot of stake in the privatization of public utilities. Privatization of public utilities is an enormous source of income for political parties in order to, produce their own financing of their own elite. So the referendum looked a really hopeless thing to do. However, for some reasons that were quite fortunate, the referendum was won with an overwhelming victory. 56% of the Italians show up, and almost 99% of them voted against the privatization of water and of all the public services. There was also a ballot called upon in the same package against the resuming of the nuclear power plan, so that all the referendum could really be seen as a popular position against some of the most fundamental structures of the neoliberal model of development, mega projects and privatizations, which is basically what has challenged the very distinction, the usual distinction between the private and the public. Right? The public and the private as a distinction, as a division, has been really torpedoed, I would say, by these two big models of development. The mega projects are the typical place in which public and private interests converge, usually against the people, and we know that very well. It's sufficient to look up some of the posters on that side, particularly the one on the dams in Brazil. And on the other hand, the privatization of assets and even privatization of sovereignty these days seems to be the model by which, the state relinquishes power to the corporation, making this process of continuous privatization a quasi-structural feature of the world we're living in. And incidentally, to go back to the paper that was produced before, it seems that intellectual property is a fascinating example of a new wave of enclosures in the cognitive economy arena, right? What happened in England 300 years ago is happening today with the internet. It's more and more usual to arrive to a place and then click, you have to pay something. That is a private app, right? So it is really an enclosure of a public space that is going on under our eyes at a very, very quick pace. So the referendum was a major victory. The victory happened without any access to the media, just by political activism. About 40,000 people were involved in the the organization. It was a really grassroots organization. No political parties were siding on our side. And that was, and it was 16 years that a referendum was not successful in Italy. So it was a big political moment. All the political parties were against it. The day after the referendum, that was presented as, a strong sign by, the anti-neoliberalism, that neoliberalism was over. The crisis was biting badly. The idea that privatizations were one of the reasons of the crisis were diffused in the population. The hegemony of the neoliberal model was dramatically declining. The neoliberal model could not really run by being sexy and seductive anymore. It had to run by the fist. And in fact, the reaction was fist. The reaction was the demise of any attempt to rule by consent, the demise of the Gramscian idea of hegemony by consent, and the introduction of a model that was simply suspension of democracy. That model was, that happened really, really quick. In a few months, a global speculation started very strongly in Italy, the same one that had been going on in Greece arrived in this country, and the state of emergency was declared by the government. The president of the republic appointed Mr. Monti because Berlusconi was in some troubles because of his sexual appetite, despite the age, and therefore we had this so-called technical government that actually was put in place to reply to a letter from the European Central Bank, in which letter there was written that things to be done included privatization. So here there was a clear example of the constituted power in office trying to walk a line that people had already before declared was not anymore the line they decided. And this was very brutal. And it happened and it's still happening today. And that model included an attempt to rush for constitutional reforms in order to be able to do those in time before the dissolution of parliament. Here there was really a constitutional problem because usually in the previous examples in which a referendum was against all of the parliament, the president would have solved the parliament and called elections. That would have been the constitutional reaction in ordinary times. However, this time the president did not solve the parliament, that was already in this final phase, and actually put a technical government that was sustained by an overwhelming majority of the parliament. And this government and this parliament, with this very strange grosse coalition kind of structure, is now doing as fast as possible a final transformation of the Italian constitution in such a way to avoid another referendum. And it was done already. It was done in complete silence of the official media. We changed Article 81 of the Constitution by constitutionalizing the balanced budget. Only country in Europe that has done so far. And they did it with a majority in parliament of more than 2/3 in the second read. That means that, because of our constitutional setting, the people cannot now vote on that crucial issue. And there is a plan that is called now doing the reforms. When you say, oh, we have to do the reforms, doing the reforms means basically doing as much constitutional transformation as possible in as little time as possible in order to be able to vote in 2013 so that we cannot go back from the actual structure of power. So this is what is going on in the official arena. There is, however, a big and strong fight going on against all of this. The lack of seductiveness of the neoliberal paradigm is very clear. We are seeing it pretty much everywhere in Europe, and I guess also in the United States, even if I've been out of there the last year, so I don't really know how it's going on. And the people are organizing in a variety of ways in order to resist this project. The idea is that the commons can become the political and legal alternative to the neoliberal vision. The challenge is really to this sort of assumed opposition between the public and the private, the public being the state, the private being, the market or the corporate logic. And this opposition doesn't hold anymore. And this opposition, this sort of faked opposition of the private and the public, is really what makes the commons suffer under this suspension of democracy model. The public and the private do share the same logic. They are logics of concentration of power, and they are a logic of exclusion. The model is that. The commons really tries to do the other thing, to go the other way around. The idea is the sharing of power, the diffusion of power, and decentralization, and particularly direct access. So how is this sort of opposition going on, and why I do claim that this opposition has some sort of constituent power in itself? Because this is the question, right? There is a constituent action in terms of changing as much as possible of the current constitution as fast as possible, in order to go away from the social constitutional model that we enacted in 1948 in the direction of a neoliberal constitution that basically puts capital ahead of labor rather than the other way around. On the other hand, there is the constitutionalization movement for the commons that is really working on constitutional ground, trying on the one hand to safeguard the current text, so to limit the transformations, and on the other hand to introduce a contextual change of the reading of the actual constitutional texture, so that the reading of the actual constitutional texture can outline and can put out very clearly what are the values and the principles that are written in any constitutional document that cannot really be changed if a constitutional document wants to remain such. And these principles are basically the defense of the people, the defense of the many, the defense of the majority today against the power of the minority, which is exactly, if you think about it, the opposite idea of the Federalist Papers, right? The Federalist Constitution, the idea was defend the minority against the minority being the property owners, the majority being all the others, and the constitutional text was needed to defend what at the time was seen as weak against the majority that was seen as strong. Today we have a completely opposite need. We have a need to defend the majority by any kind of constitutional means against a minority that became so powerful and strong to be able to control the very constitutional text. Now the action here is on a variety of levels. There is, of course, a legal action. And legal action is grounded in a number of struggles that are going on and in which we claim that the legality model that is used today by those in power is fundamentally legal. And there are legal actions going on against the big train in the Susa Valley, which is kind of one of the big issues in which the clash between the two visions is happening in this country. And when I talk about the clash, I talk about physical clashes. I talk about the cops on the one hand, the people on the other, and people actually fighting and struggling on a physical ground. It's not, abstract. It's really happening in the name of the commons. And that is happening, in the occupation movement that in Italy is very strong. It started a year ago, and with occupations of mostly of a famous theater in Rome, and then from there a large number of other similar instances. Yesterday afternoon I actually went to Milano, where we have one occupation of a big skyscrapers happening. So these things are really happening in the streets. And there are legal fights over it. There are legal fights that get to the constitutional court, that get to the administrative court, that get to the ordinary courts. And those legal fights are all grounded in trying to abstract from the constitutional text a vision of the commons, an idea of the direct defense of the people against power that actually is slowly emerging in a variety of victories that we are obtaining. The commons is becoming illegal, even if the Rodota Commission was not passed into law. However, we had already decisions of a variety of courts of law that are using the category and that are putting this idea of the direct satisfaction of the needs of the people ahead in the construction of a legal order that is actually claiming to be legitimate. Am I done? How many minutes? 1 minute? Couple more minutes. Okay. So that's one side. So we have occupations, we have legal struggles, and we have also an action that is carried on at the European level, trying to produce documents and charters that, at the European level, make the common as a limit to the possibility of corporate power to expand. And here, it's a really sort of counter-hegemonic use in way of European law, because the spaces of European democracy, and particularly of initiatives, are very, very narrow. There is a European initiative, but is practically a joke. It's as democratic as the one that was described this morning in the setting the standards of finance, have consultations, this kind of, completely empty exercises of vague rhetoric of participation. And this Article 11 of the Lisbon Treaty is exactly the same thing. They say, if 1 million people ask the Commission to do something, then the Commission might do something. And should the people be on the street? No, do it over the internet. So that there is no actually risk that politics becomes physical again. So this whole thing is happening here in Italy today. And the paper tries to describe what is going on, tries to describe the fundamental claim, and the fundamental claim is that this is a constituent clash going on. The crisis has showed the conditions for a constitutional transformation. These constitutional transformations are happening in different countries, and the tension between democracy, participation, and capital accumulation is now so strong that I don't think any scholarly activity on constitutional law can avoid tackling it. Thank you.
Okay, so people can either ask questions or take to the streets.
I'm wondering with this story if there is any room to speak of functional differentiation then.
No.
Like if the Constitution is meant to prevent illegal use of power, then you can actually bend the Constitution and write in the Constitution whatever you want to against a referendum. Then of course, you have these two sides of people on the street and the courts. And are the courts the same way independent as the parliament is? Can we talk about functional differentiation in this context?
Well, it seems to me that there is a big difference right now going on from this point of view. If I understand your question well, you're saying you're basically saying, well, if you change the Constitution, you go through legal means that are formally legal. On the other hand, these formally legal means if they are formally legal, they cannot be challenged in courts. That's what you're saying, right? In fact, yeah.
I hope they can be challenged in court in the sense that I hope there are clauses in the Constitution that the new provisions have put in can be brought to bear against other sides of it, the same way that, for example, happens in judicial review in the United States. That yes, there are tons of statutes on the books that might be quote-unquote illegal. They're political decisions, but we don't know if they're legal until they come to the court, and then they might appear to be illegal. But they may never come to the court if there is not that external mobilization.
Yeah, but one thing are the statutes, one thing is the Constitution. Here the change is directly affecting the Constitution, you see. So when you change the constitutional text, and then you change the constitutional text with such a formal majority that is sufficient to avoid the referendum, when you know that the parliament has about 10% of national credibility or availability, you are doing whatever is formally required to actually amend the Constitution, right? And on the other hand, this amendment is in direct contrast of the expressed will of the people as it was expressed just a few months before in a referendum campaign. So there is this very interesting tension between, the formal way in which legitimate constitutional power can be created, which is by getting a majority in the sitting parliament. There has been no golpe, there has been no coup d'etat or anything like that. We are within the clear formal limits of formal constitutionalism by interpretation of the current setting by the president, but we are formally within the constitution. However, this formal constitutional transformation is substantially at odds, actually is in direct clash with the direct pronunciation of the people just a few months before. And so here we have really two constituent moments, because the people that cannot be represented in the formal constitutional making process, which is actually the opposite to them, needs to find representation by other means, which might be illegal formally, like occupations or things like that, but they may also be legal if they are able to create contradictions between the legislature and the courts, for example. You see? So there is a dimension of the constitutionality in all of this. The Constitutional Court cannot challenge the formal text of the Constitution. However, it can change the aggregate of provisions that are actually leading in the direction of changing the actual text of the Constitution. I don't know if
It brings me back to the question of the central role of the court.
Oh, the courts are stuffed with people, they're stuffed with judges. That means, and that means that these people that stuff the courts, this is not cynical at all. I'm a very sort of mainstream legal realist in my analysis of courts. I'm not like claiming big, conspiracy stuff. No, I just believe that courts are stuffed with people. People went to university in a certain time, especially at the Constitutional Court level. Today, the judges that are sitting there were students in the university at the times in which neoliberalism was not there yet. And so the theory of rights, the idea that the system should proceed incrementally in order to raise equality, the idea that labor was central in the organization of Italy, all these kind of ideas were those that were taught and discussed at the university in the years in which these judges were formed, which was also the years in which I was formed at the university. So these judges carry with them a certain culture of rights, of social vision, a certain idea of democracy, okay? Which today is completely obsolete if you compare it with the idea that dominates the parliament. Because the parliament is made of politicians, and the politicians are basically under, they are basically controlled by a discourse that is the neoliberal discourse. And so the majority of this exchange in the Constitution runs a neoliberal discourse, which is at big odds with whatever was taught in universities at the time in which the judges were studying at the university. Therefore, it happens more and more often that some of these changes that the parliament carried on arrive at the Constitutional Court, and the Constitutional Court says, sorry, no, you cannot do that. There are some fundamental values here by which you cannot do that. And that's what we hope will happen like next month when we have the challenge of the bill. Because I forgot to say that right after the referendum, they immediately passed two bills, one of the Berlusconi government and the other of the Monti government, basically canceling the decision of the referendum and putting again compulsory the sale of all public utilities. They kept the exception of water, because that would have been really a little bit too much. But the idea that the public services were to be privatized anyway was written into formal law, which actually claimed to do that in light of the future transformations of the Constitution. There is this written in the law, Waiting for the changes of article blah blah, we start doing this, which is a very interesting kind of constitution making power. So I think it's really an open question. It's a matter of strength at this point, right? It's a matter of strength, it's a matter of political activism, it's a matter of, bringing back politics in the center of what people are interested in doing. And we cannot really say who will have the final word. Whether, there is going to be actually a successful effort to pacify what is going on, by just keeping using some sort of a discourse that makes illegal political engagement. Because once you declare a state of emergency, then the first thing that dies is the idea of a loyal opposition. If there is a state of emergency, you do opposition, you're not loyal. And that is really sort of the technique that is used in emergency. That was very, very clear in the United States after September 11, right? Whoever was discussing that was kind of, opposing something that should not be opposed because we are in an emergency. And now you see the permanent emergency has been declared in this country. The not to end up like Greece. That's the ordinary discourse. And the point is, if you can actually imagine that an important economy like the Italian one decides to walk another line and arrives to a dimension of power in which this walking another line gets successful, that seems to me that can start a transformation in the global constitution making process that might be extremely important and interesting.
Yes. We are here in a scholarly debate on social constitutionalism, and the object is, of course, moving into it. So our debate is not just on theoretical lines and cleavages, but of course also on political cleavages, and we feel it all the time, don't we? But the interesting thing is, we don't say to each other, hey, you are wrong, you are my enemy in the Carl Schmitt sense. No, we offer to each other caveats. Right? Much more polite. And so I have caveats for you, right? So cave canem, beware of the dog, and of course underlying the hope that the dog will bite. So first, the commons movement, I think, is a perfect example of societal constitutionalism in two senses. One, that one sees that the pouvoir constituant cannot any longer be seen as, in this kind of traditional sense, as the power that is, in a sense, constituting that state power, rather than it moves into society and makes there its fights and movements. And some people say that it is the very direction, the very addresses that protest movements seek today. No longer parliaments and governments, rather corporations, private actors and all that, is a very significant change in the constitutional situation today. So in this sense, constitutionalism, and of course in the other sense, that the commons itself, common property, and how it will be managed and how it will be done, all this is a deep question of constitutionalism, again, not in the political state sense, but in the social sense. So it's comparable to worker participation, it's comparable to consumer movements, it's comparable to ecological movements, and so on. Now comes the dogs, the caveats. One is the Beelzebub devil syndrome. I mean, aren't you driving out with this, your engagement for the commons, aren't you driving out the devil by Beelzebub? And I mean, the blunt question is, the danger of all this is that you replace the market capture we were talking about yesterday by a political party capture. And we have so many examples of a commons regime which tended in this direction. Take the media industry, sometimes private, sometimes when it's public, and the usual thing, we have Italy, we have Germany as the two examples, usual thing, when it's public, of course it's created, it's an independent institution, it has autonomy against political interference, and what comes out is, of course, the takeover of political parties. Right? The necessary politicization of these things. And this happens to the industry, it happens also in this country. I mean, we talk about the lotticizzazione in the universities, the politicization of social institutions that have different things to do than just make political fights, and then the universities are just split up according to political allegiances. Right? So here we have the kind of wrong constitutionalization, and I think there is this great danger in the common movement, and you could also see this in the water question. How can one make sure that the opposite of the market capture will not happen with this political party capture? And this is where I see the one danger. The other one has to do with the triangle between the private property, and then what's the counter principle? Is it the commons or is it the public? And I have the feeling for people who, like you, go ahead with the kind of constitutionalization of the commons as a constitutional principle, are exposed to the tu quoque exception. Aren't they doing the same thing when they want to give constitutional status to the common property, that they are doing the same thing what they criticize, what their enemies are doing, namely making out of private property a priori principle, which cannot be overcome by political public debate, rather which is enshrined. And so what the commons movement is trying to do is a similar thing, enshrining the commons in such a way that the public debate cannot even change that. So I wonder about this interrelation, if one should not be, if the commons is not a question that should be decided politically, but not on a fundamental basis, but rather on the question, in which question should one introduce a commons regime and draw the line between the profit sector and this kind of commons sector in consideration of very, shall I say, pragmatic questions.
Should I answer or should we get... Maybe I should answer.
You can answer.
Yeah, okay. Well, I try to be brief because I want to get some more, but your first question was actually deeply debated in Italy at the public level during the referendum campaign. We actually had our most challenging task to persuade the people of Italy, that is a very lottizzato country. It's a country in which the political parties are extremely intrusive and people don't love them at all. So we were exactly accused of, fighting privatization of water, doing, a big courtesy to the political parties. And we spent a lot of time, and that, it seems to me, was the most important part of the commons argument, actually persuading a majority of the country that dealing with water as a common was not the same thing of going back to the public in the sense of the bureaucratic, hierarchical structure of power. And we also used some examples, and now there are certain places in the country, such as Naples, in which we are working out structures of governance that are participated in the sense of having the people directly involved in the controlling of the resource. So so the first question was debated politically. Of course, it's an open question, but of course the commons. You see, we see on one side the private public faked the division, and the commons on the other part. The second answer would be, of course, you see, when the Rodotà Commission example was a legislative effort, and therefore worked into the framework of legislation. We went with an example of what are the commons. We didn't want to essentialize the commons at all. Ever since it became very clear in the common movement that the first step to see something as a common is the public recognition of it as such. Right? So the idea, university as a common, or culture as a common, or the territory as a common, or the environment as a common, it's not something that you kind of put it top down. It's something that is actually recognized by a significant number of people that are willing to engage to actually put down political effort to defend it directly. So it's a very variable notion, and in that sense it's really the political process that defines what's the commons, but it is not the political process as the one that goes on in representative democracy.
Okay, we have 4 questions which I want to aggregate. So we've got an audience member here, we've got Saskia, we have an audience member in the back, and we have Don. So let's get all 4 questions, and then you can get one last response.
I would like to make a comment on this example from Brazil, from this dam, Belo Monte. I'm a Brazilian PhD candidate in Frankfurt, and I don't know if I'm well informed, but I think this project is carried out, so mostly, by the development bank. The private participation in this project, I don't know, it's about 30% or 20, I don't know. And I would put the question not as a political question, as you put, so a majority problem to vote against the dam, but I would say that this may be a constitutional problem in the sense to protect a minority. because it's simple to understand this. So economic growth needs energy, and the politicals in Brazil, they're needing this energy. And if we take a referendum in Brazil now, I think the people would vote for the dam, because the economic growth is good now in Brazil for the people. And I think this is not a question of so much the private corporations that are exploring Brazil. But I think now in Brazil, it's the problem of the expansion of economy, exploring more than only economic. And I will put that in a traditional constitutionalism, or not traditional, but as now it's the problem to protect some minorities, Indians, environment, and so on and so on. So I think this problem from Belo Monte, we can resolve that without this strong political sense, without constitutional. We could resolve this in the realm of constitutionalism.
Okay, Saskia? And you can bring the other microphone can go back.
Just a very quick question, Ugo. The notion that you have of constitutionalizing movement. So I understand that to mean, in this particular case, and my question is how can one generalize to other cases, is that it has been a referendum. You have a social constitution that recognizes constituting power, I guess, or some version of that kind of referendum. We have a lot of referendums in the United States. They are totally different. And so, do you mean by constitutionalizing movement something that is marked by these kinds of disciplinary enablements and confinements? Then the Bolshevik Revolution, the French Revolution, to mention some famous ones, they are not constitutionalizing movements, right? I want to know how, because I think there is often an advantage to having a very precise meaning for something and not generalizing too much, not any revolution, in other words. So it happens within a constitutional setting that is there, right? Because this is the way, you're not changing the whole constitution, right? Or am I missing something? And then secondly, if we take that narrow definition, what are the familiar, that you might know, it's an empirical question now, trajectories of constitutionalizing movements when they succeed, etc.? For instance, has Italy other precedents? And this question is really asked in the narrow sense of constitutionalizing movement. Mi capisci, sì?
Assolutamente.
Dr. Mattei, grazie. Thank you for clarifying back here. Thank you for clarifying this interesting question. Very local, but I guess it can be used as a reference in many constitutional participation debates elsewhere. I'd just like to point out, or perhaps ask you how do you see this? If I understood correctly, one of the points of your explanation or your suggestions to this movement, you suggest the possibility of transferring to the courts or making some clauses immutable, some principles of the Constitution immutable, even to constitutional amendment, and I perhaps see there a potential contradiction or a threat to the idea of bringing more democratic participation to this process, since, well, you have these sort of immutable clauses in many constitutions in other parts of the world, and in some situations this brings, or you take out of the parliament the power to amend them, but then you give to the court the power to interpret them. That power keeps open just to those 9 Supreme Court judges, depending on the country. So you freeze this potential change in another context, perhaps not now. Now it's not interesting to have this potential change on the hands of the parliament, and you see in a very you see with hope what the courts, how the courts could protect the Constitution at this moment. But my point is, Indian Constitution, New Eastern European Constitution, Brazilian Constitution, and many others, they have these immutable clauses, and these, in many situations, put in the hands of the judges, very conservative judges in many situations, the power of interpreting and reinterpreting those clauses, and this takes out of the parliament the power to the sovereign power to change that in another one. So my question is, in the long run, in the middle range, in short term, on a middle term, long term, maybe this could cause harm to the people of Italy.
Okay, one last question from Don. Can you ask it?
Short question. Is there a way to link up the issue of the Constitution with the theory of infrastructure? I totally buy in your idea of that the occupation movement takes place in the name of the commons, and that implies a constitutional moment in the sense of Tortner. But is there maybe a way to define this constitutional moment? And when I talk about the idea of infrastructure theory deals with the idea that an infrastructure is defined by a plurivalent structure, by a pluripotentiality structure. So when in the moment the usual avenues to engage in politics and to reflect, to articulate the will of the people are closed, and these avenues are closed, but the multitude of systems is effected simultaneously. Is that the moment, the constitutional moment? So that that we have to wait until a moment where a whole variety of systems are negatively affected at the same time. Not just one system is injured, but many systems lack their environmental conditions to work, and that applies to physical infrastructures such as water, as well as intellectual infrastructures such as the use of a robust internet background.
Okay, a lot to respond to.
Yeah, I will try to be short, of course. Well, the first question, I would say, the one about Brazil, I would say that a vision from the commons perspective of a mega project like the dam, as much as a vision from the commons perspective of a mega structure like a nuclear power plant, or even of a big infrastructure such as a tunnel under the Alps, very long one, is that the narrative around these infrastructures never corresponds to the reality by which they are done. In other words, the nuclear industry is not about production of energy. It's about concentration of power, it's about constructing society in a hierarchical authoritarian way. The production of power by nuclear plants is trivial throughout the world. With switching off the lights in Tokyo, it was possible to save as much energy as was produced by Fukushima. So, the level of the comparative ratio of energy that can be produced by the nukes is practically none. There are studies that if we had to substitute the whole hydrocarbonian production, whatever we do with energy from oil and from coal with nukes, we would have a reserve of uranium that would last 3 years. So the nukes is not about a long-term plan of substitution. Similarly, the dams are very there are lots of studies now in the commons literature that the decentralized production of energy and the saving of energy is much more efficient from the point of view of production. Just talking about the brutal concept like efficiency than building a major dam. However, a big dam is a huge source of concentration of power and concentration of money, and therefore it is justified in its own terms. Okay? The fact that the Brazilian people who vote for the dam is very simple to understand. It's exactly the reason why the Italians will vote for the tunnel up there. That the community, the discourse, there is a governmentality aspect of the media industry that works to keep the people unaware of what is going on. It is sufficient to have the people engaged in actual action, that there is a level of self-information and self-understanding of what is going on that is huge, and that produces a lot of collective intelligence that then can be put at work in order to organize a society in a better way than the exploitative one we have right now. As to Saskia, here really it's about the constitution in action we're talking about. I think that your comments and his comments were kind of similar. What I mean by a constitutional moment? I used, very plain Bruce Ackerman idea that there are certain moments in the history of a country that produce social tensions and social transformations that then reflected on the fabric of the law that then be considered constitutional moments. Okay, so for example, the crisis of 1929 was certainly a constitutional moment for the United States, and not only for the United States. The welfare state system, the Lochner era was over. I mean, all sorts of things like that happened around that kind of constitutional interpretation generalized scheme. And, the World War I would be another very important example, but we can find many. And the claim here is that right now we are in a constitutional moment because the hegemonic part of neoliberalism that was actually successful in keeping itself a sort of desirable model of development collapsed in the last 4 or 5 years. And so the conditions of the context are ripe to transform the text by a different read of it. But the text really stands still. Oh, absolutely. I mean, the text stands still. What the interesting is that the power is going to the text. So it's neoliberalism that is getting textual, because they are losing, they are losing the complexity of the machinery of applying the law, and therefore they get textual. They say, at least we get that, Then we get out of here, but we got this, and then they are going to be in trouble to read something else in that. So it's really, so when I talk about the constitutional moment, I talk about something that happens in the context and then is reflected in the general read of a document by the people and by the legal officers, including the judges. The constituent power belongs to the people and talks the language of the law. That's the feeling of justice and injustice, the idea of how society should be like. All those kind of things stem from the people, and then the lawyers kind of write it down in a way that is understandable by other lawyers and works institutionally. But I regard really the role of the lawyers who are actually engaged in these transformations to try to understand. It's very Sabinian in a way, to try to understand the false guys, what the people think about the law at that moment, and put it in legal terms that work. And the thing of the immutability of the Constitution. This is again, the reason why I presented this very local story is that I think that this local story, because it happens in the context of a constitution, has some general relevance. So it doesn't really matter what is written down in the Constitution. In the Italian Constitution, there is a provision that says that the Republican form cannot be amended even by the usual constitutional amendment process. So the idea that we could not go back to monarchy, we could not go back to an authoritarian fascist government, that's written down there. But of course, we're talking about constitutional power. That means that it's written down there. But if you have enough power to rip off the Constitution, you can write whatever you want. So it's really, it seems to me, a very circular argument. If a text can say you cannot change me under any circumstance, a generation will change what the previous generation has done if the political conditions change. So I don't think that is a problem per se. And I think I took care of most of the questions, I guess. I don't know. The courts. The last thing about the role of the courts. It seems to me that the courts here are called upon as one of the strategies. Of course, nobody. You see, I see a very different story going on from the human rights movement in the United States, for example. The global human rights movement are lawyers and courts of law that actually use the law in order to generate a political process, that is calling corporations, to their responsibility, or taking some dictators in Latin America and carrying it to Florida to courts or whatever. In that case, the law really works in its own terms, interprets its own kind of structural setting and is at risk of becoming very universalistic and therefore imperialistic. So I have a problem with that, because it's a lawyer's kind of thing that stays at the domain of the changing of the formal law. Whereas the commons movement uses the law in another way. It's not generated by the law at all. It's something that is generated by actual conflicts and struggles that then, the law tries to translate and to make it usable in court with a variety of means. But the use of the courts of law is clearly just a little part of it, and it's defensive. We just try, by the use of the court, we just try not to get worse, or at least to slow down how fast we're getting worse, in order to have the possibility and to free energy for getting better on the other side. So it's part of a strategy in which you have your defense in place before attacking. If you don't have the defense in place, then you get attacked on that side. And they're using incarceration a lot. People get in jail for these things. For example, for the state of emergency for the big train in the Susa Valley, there is a provision that if you protest and your protest is not allowing the workers to get to the workspace, it's a crime and is punished with up to 1 year of prison. And there are about 15 people that are laying in prison today for demonstrations. So we're talking about a real conflict, and the law is used usually by the side of power. And if we can use it a little bit also on the side of defense, is very important.
Okay, thank you very much. We have run over, but we are going to begin again at 2 o'clock, continuing the schedule, so we'll just have a shorter lunch break.